Good afternoon and welcome to the Taking and Enforcing Security in Europe webinar from Taylor Wessing. My name is Neil Smith. I'm a partner in the Restructuring Corporate Recovery Group here at Taylor Wessing in London. Following the launch of the refreshed ebook version of our Taking and Enforcing Security in Europe guide in January, we are hosting this webinar today so that you can hear from all of our European offices that have restructuring expertise to talk about taking and enforcing security in those countries, the main point or points that you need to know if that's what you are thinking to do. Before I hand over to the first presentation, just to let you know that you should be able to see on your screen a number of what I understand are called widgets, boxes for you to press. The Q&A is for you to ask questions which you can type and send in at any stage during the webinar. Please do those. We will have time at the end of this webinar to deal with those questions, which I will put to the appropriate presenter and the appropriate country. But please let us have your questions and we will try and deal with as many of those questions as we can before we conclude at 5 o'clock UK time. The link box is a link to the ebook that you can press at any time if you want to have a look at that book as we go through the webinar. There is a survey which we would ask you to complete. You can either complete that during the webinar or at the end. And just to confirm, and I'll confirm this also at the end, that we will be sending a recording of this webinar to everyone who is invited to it. So if you're not able to listen to all of it, or if you weren't able to listen to this live broadcast, then you will still be able to hear it, and we will send a link and also the slides, so you've got a copy of those as well. So I will now pass over to the first presenter, and I will summarise at the end and then pick up your questions. And without further ado, we'll pass over to my Austrian restructuring partner, Susanna Fröstrofer.
Hello, I'm a partner in Vienna and from time to time also appointed as insolvency administrator by the Commercial Court Vienna. Well, in Austria, like in most continental jurisdictions, we do not have a security instrument as the floating charge. Austria still follows, and in my opinion, will also follow in the future the principle of speciality. A security can only be perfected relating to each specific asset, or under certain conditions also a group of assets, like all receivables of a company. Forms of security are mortgage, pledge, transfer of ownership by way of security, security assignment, and retention of title. The formal requirements in Austria are rather low. Only a mortgage on land and for registered intellectual property rights like trademarks and patents, you need a notarized deed and the registration in the relevant register, like land register, trademark register. On the other hand, however, a pledge of movables requires a physical delivery to the creditor, the pledgee. In German, we call this the Faustpfandprinzip. If physical delivery is not possible, for example in the case of aircrafts or heavy machinery, a symbolic delivery by attaching plates, marks or other signs is deemed to be sufficient. If a symbolic transfer can create a valid pledge is decided by the Supreme Court on a case-to-case basis. The Supreme Court has taken a very restrictive view in the past and in many cases argued that the physical handing over of the pledged asset is in fact feasible. A register for the pledge of movables does not exist, although there are since a long time discussions to install such a register. The same requirements as for pledges apply for the transfer of ownership by way of security. Therefore, this instrument does not really exist in practice with regard to movables like cars and so on. Receivables, however, can be assigned for security. Necessary is either the notification of the third-party debtor or by making a so-called Buchvermerk, a book entry in the books of account of the debtor. One of the first checks when I am appointed insolvency administrator is always whether there is such a book entry, as otherwise the receivables belong to me, the insolvency estate, and not to the bank. The second check is when the book entry was installed. If it was done during the last year before opening of proceedings, it can be challenged and the receivables again belong to the estate. A very important security in praxis is retention of title. No registration or notary public is required. Just an agreement between the seller and the purchaser before delivery of the goods. Retention of title can also be transferred to the financing creditor. This is made in praxis by an agreement between the seller and the buyer on the retention of title and a subsequent order of the buyer to his bank to pay the purchase price to the seller. Retention of title then passes to the bank with payment of the purchase price. You see, this construction has the same effect as a transfer of ownership by way of security. As we will see in the course of this webinar, the results are often the same in the various jurisdictions. Just the way to get there is different. And so I pass on to the Czech Republic.
Thank you. Hello, my name is Thomas Rechberger and I'm a partner in the Prague office. We would like to give you a short overview of the right of pledge to receivables in light of the new Czech Civil Code. The old Civil Code stipulated that under certain circumstances, a negative pledge, which is an agreement between parties that the pledger cannot create, a pledge over a certain thing was allowed, but effective always only between the parties to the contract. With the new Civil Code in effect, this changes. The negative pledge can now have effects towards a third person, if it is registered in the notarial pledge register or a public register. Before the new Civil Code came into force, all of the stipulations regarding forfeiture were invalid and considered as an unacceptable restriction of ownership rights. Today, the legal practice allows for negotiating about the forfeiture even before the maturity of the debt, if the price will be determined objectively by an expert's opinion to the date of maturity of the debt. In any case, the stipulation with the content mentioned above is disregarded if the pledger is a consumer or a person who is a small or medium-sized entrepreneur, regardless of how they were stipulated before or after the secured debt became due. Under the same circumstances, the new Civil Code enables the pledgee to sell the pledged thing, besides other than in a public auction or a judicial sale of the pledged thing in a private sale. The new Czech civil law provides for, compared to the old law, new methods of establishing pledges to receivables. In the old civil code, the contractual imposition was the only possibility, and the contract required a written form. The time of the pledge becoming effective was either at the closure of the contract or at a different time arranged by the parties. The original option of imposing a pledge through a contract remains unchanged, also in the new civil code. There is, however, a second possibility of forming a pledge, and that is by registering it in a notarial pledge register. For registering a pledge in the register, the law requires a contract in the form of a notarial deed, which means increased costs. A third option is to choose the classical written form and to agree on and register a negative pledge, for which no notarial deed is required. In fact, it is sufficient if the signatures on the stipulation about the negative pledge are verified before a notary public, and the negative pledge is subsequently registered in the pledge register or in a public land register. The notarial pledge register is not a public register, and that brings certain problems. There is no notification obligation of the creditor towards the debtor to inform him that his receivable is becoming a pledge in favor of a third person. If the debtor was paying to a wrong person who might be insolvent and incapable of paying this wrongly performed debt back, ignorance of a standing pledge would not relieve the debtor of his duty to pay the debt to the pledgee. The register does not have a unified description vocabulary for the subjects of the pledges, which causes confusion in the identification of the register's pledges to receivables. In general, it is difficult to describe a pledge with certainty that it would be easily findable. The main purpose and advantage of the notarial pledge register is to give satisfaction priority to those pledges that are registered, because the law states that pledges registered in the pledge register or a public register are to be satisfied first. Because the register itself is run by public notaries and the information from the register is accessible to the public only upon written request, it is apparent that transparency of the register was not the main aim of its creation. This should, however, change in the future, as there is a demand coming not only from a concerned public, but also from authorities such as the General Financial Directory. The pledge register should become an open, available tool for the creditors and public. Model registers for it shall be the commercial register and the land register. It is, however, difficult to foresee when this register will be realized. Thank you for your attention, and I would like to hand over now to Paris.
Good afternoon. My name is Alfred Pink. I'm corporate partner in Paris office, heading the Insolvency and Restructuring Department. With regard to the legal situation in France, I allow myself to refer to the French chapter of our publication, Taking and Enforcing Security in Europe. I thought that I should use my time slot today to introduce you to the new legislation with regard to the pledge of inventory in France, which is a regulation which was regularly disputed in front of French courts over the last 2 years. The legislator issued an ordinance on January 29, 2016, by which it redrafted more or less the set of rules in the commercial code. Under French law, you will find the ordinary regulation of a pledge in the articles of the French Civil Code, which distinguish the pledge of with dispossession, possessory pledge, and without dispossession, non-possessory pledge. The possessory pledge requires for its completion that the debtor will no longer be in the position to dispose of the inventory, while the non-possessory pledge requires a registration with the relevant commercial register. The main difference lies so far in the fact that the non-possessory pledge is disclosed through its registration to all interested parties and creditors, while the possessory pledge is not disclosed and other creditors of the debtor are not informed, and they don't have any means to get the information except walking by the company and have a look in the inventory. In 2006, when the reform of the security interest took place in France, the legislator introduced a special regulation in the commercial code applicable to credit institutions and financial companies financing French corporates. It was understood that the credit institutions and financial companies could only apply the commercial code provision and were only entitled to establish a non-possessory pledge with registration and disclosure. This situation was approved by the French High Court, which then also allowed that a credit institution could go back to the general rules of the Civil Code and apply for the possessory pledge. The ordinance now redrafted the commercial code stipulations entirely and introduced the pledge of inventory with and without dispossession in the commercial code. The perfection of the pledge of inventory without dispossession requires, as before, as also under the ordinary regulation of the Civil Code, registration with the commercial court, while the pledge with dispossession is effective with its establishment. But, and that is a but with in large letters, the new regulation provides that the pledge with dispossession can only be opposed to third parties, other creditors of the debtor, if and when the pledge was notified to the creditors. So we have a tremendous change with regard to the with the possessory pledge in the commercial code, as it can be established without any formality except dispossessing the debtor, but it can only be opposed to creditors, other creditors of the debtor, when it was notified. Hence, the notification to the other creditors is not a condition for its effectiveness, but of its third-party effect in the enforcement phase, or even more important, in the insolvency procedure. Then the ordinance stipulates that the parties may choose a set of rules they would like to apply to the pledge agreement. That sounds in the first instance quite strange, because you have the impression that there's a general rule in the Civil Code, and there are special rules for credit institutions and financial companies in the Commercial Code. Here, this distinction is broken down to a certain extent, and nobody really knows what the government has thought about this regulation, which may be corrected in the law which has to come for the ratification of the ordinance which was issued by the government. You will not be surprised that the credit institutions and the financial companies tend to apply the rules of the Civil Code when taking a pledge of inventory with dispossession, since there are no further formalities to be applied than to organize the dispossession of the debtor. And in addition, they can obtain the pledge over the entire stock in good faith if the management declares that the company is the owner of its inventory. In other words, that does mean that if there's a supplier who has concluded with the debtor a retention of title clause, he would lose out to the pledgee because he was in good faith when he took the pledge. So the credit institution would have priority in the insolvency proceedings over the supplier. So that is, from our point of view, quite important to keep in mind that in France we have the choice between the two codes, and that a creditor, a particular credit institution, may be in the position to obtain a pledge in good faith which overrides the right of a supplier who has either negotiated a retention of title clause, or he was a person under a tooling agreement who provided material which has only been transformed. Then the last and also important modification is that the parties to the pledge of inventory may agree on a private enforcement clause, meaning that the pledgee will become owner of the inventory if and when a defined event of default occurs. I think that is the three changements which were introduced by this law are quite important and to be kept in mind by foreigners who do business in France as suppliers or credit institutions to be in the position to save their interests. I hand on to my colleague Daniel Kunz from Germany.
Hi everybody, my name is Daniel and I am a senior associate in the Düsseldorf office. What I would like to focus on is the practical question, what happens with securities when it comes to insolvency in Germany? Or in other words, how do insolvency proceedings influence the enforcement of security rights? What disadvantages might occur? And how can these disadvantages be avoided? As a general rule, there is an automatic stay for unsecured creditors on the opening of the insolvency proceedings. As a secured creditor, however, this can be different. Whether or not secured creditors remain entitled to enforce collateral depends on the type of collateral. In the next 5 minutes, I will introduce two typical collaterals to secure credits: the land charge and security transfer over movable assets. So let's start with the land charge. Generally, the secured creditor remains entitled to initiate the enforcement of the land charge by way of a forced auction. However, important to note is that the insolvency administrator is also entitled to initiate compulsory sale at auction. In this instance, the secured creditors have a preferential right to satisfaction of the secured claims. When it comes to a forced auction, the result is often much lower compared to private sales. Proceeds generated by a private sale are typically 15 to 30% higher, and forced auctions proceedings take their time. The foreclosing courts are usually very busy in Germany. So a forced auction proceeding may take in most cases between half a year and a year, sometimes even longer. So the relevant question is, what can creditors do to avoid realizing land charges below value in a lengthy process? In many cases, the creditor and the administrator will reach an agreement allowing the transaction to proceed without having to go through enforced sale. Instead, property is sold by private sale. Such private sales are generally cheaper, quicker, and promise to generate higher revenues. This sounds to be a very promising alternative, but a few hurdles need to be overcome. If there are several land charge creditors with different rankings, in practice, all land charge creditors need to be part of the agreement with the insolvency administrator. The reason is that any lower ranking land charge will only be automatically released in a forced sale by public auction, but not in a private sale. As a consequence, a land charge creditor not party to the agreement would probably enforce its rights under the land charge and apply for a forced sale by public auction. And if the junior creditor does not, in a private sale, the remaining lower-ranking incumbents would affect the purchase price. So, junior creditors can use their security as a form of pressure. In practice, what junior secured creditors often do is that they demand a buyout payment for the release of its land charge. But still, agreements on private sale are most of the time beneficial to all parties. So let's move on and have a look at tangible movable properties such as inventory and stocks. Security over movable assets is created by way of transferring ownership of a certain asset to the secured party. If the secured assets are in the possession of the insolvency administrator, it is only him who is entitled to realize the collateral, and the secured creditor remains entitled to preferential satisfaction of its secured claim out of the proceed of realization. The costs of determination and realization are to be paid to the insolvency estate in advance from the proceeds of realization. The German Insolvency Code generally applies a flat rate of 9% for these costs. As a result, these costs often lead to a partial debt loss of the secured creditors. Especially in large-scale insolvency proceedings, secured creditors are often facing further problems. One of the most common problems is that the secured assets are not clearly identifiable. Very often, it is just unclear to whom a specific asset belongs to and if it has already been paid. This is not just a practical problem, but also a legal one. Just like in Austria, Germany requires a precise description of the transferred assets, which enables a third party to physically identify the assets. So what secured creditors often do, if it is unclear whether collateral belongs to one secured creditor or another, they pool their security rights. The pool allows to use the collateral for the benefit of all participating creditors. However, it should be borne in mind that only existing security interests can be pooled. Pooling does not create additional security interest and does not extend existing ones. Therefore, pool leaders will need to look very carefully that only creditors with legally valid security rights are entitled to join the creditors pool. If unsecured creditors also do join, the security rights of the secured creditors will be diluted. So summing up so far, there are certain methods such as pooling and private sales which allow to increase the value of securities. The most dangerous threat for secured creditors in insolvency proceedings is, however, not the lacking value of securities. The most dangerous threat is if the insolvency administrator challenges the security on the grounds of German clawback law, which is a very powerful tool. The most dangerous scenarios are if the security is granted for an already existing debt, or if an upstream guarantee is granted which is subject to the rule of capital maintenance. In practice, insolvency administrators look very carefully if securities can be challenged. In order to minimize such clawback risk, legal advice should be taken before securing assets in Germany. I now pass on to Hungary. Thorsten.
Thank you, Daniel. My name is Thorsten Branner. I'm a partner in the Budapest office, and I have good news from Hungary for creditors. At the moment, there is a reform of the civil code debated in the Hungarian parliament. The act will probably be adopted still in June, and it will enter into force partly on the 1st of July and partly on the 1st of October. I want to talk about 4 aspects of this specific new legislation. First is the independent mortgage on real estate in favor of banks. The second one is a call options transfer by security and assignment for security. The third topic are security trustee arrangements, and the fourth is the transfer of loan and credit agreements. So let's start with the independent mortgage on real estate. There has already been legislation about independent pledges in Hungary before 2014, but there was a lot of misuse in several cases by purchasers of the pledges. There was the real danger for the debtors to having to pay or having to fulfill twice. And so in the practice, there was the majority opinion that change is necessary and the pledges' rights had to be protected more. But the legislator did react in a way not to reform this institute, but to terminate it as a whole. And this, on the other hand, was not received well by legal practitioners and also not by creditors. And after several protests, the legislator decided to reintroduce the independent mortgage, limited to real estate as a security, and beneficiaries can only be financial institutions. This independent mortgage is transferable independently from the secured claim. The parties have to enter into a security contract, and the pledges' rights are more secured than formerly. So the possibility to claim for deletion is given for the debtor in case the secured liability doesn't exist anymore. And this independent mortgage is expected to be widely used in securitization practice. The second one, call options and also transfer by security and assignments for security. All those institutes have been widely in place in Hungary and especially used by banks for securing their claims. Then in 2014, the legislator decided to declare all of those null and void if they are created for the securitization of payment claims. And this not only in the relationship between banks and consumers, but also in the relationship to other business associations. That was the background of that decision was the concept of the legislator to have only pledges for the securitization of payment claims and no such special securities. So this was extremely badly received in the practice, and therefore also in this regard the legislator reintroduced now for non-consumers those securities, meaning that now we have more flexibility for banks and also their corporate clients. This is a liberalization which we have now in Hungary, and those securities are very good instruments in case of normal event of default, so we can avoid the lengthy and cost-intensive enforcement proceedings. The third point, security trustee arrangements. These arrangements already existed since the change of the communist or socialist regime to market economy in Hungary, but they have not been regulated in the civil code until 2014. Therefore, there was a kind of risky situation for the creditors. And then in 2014, it was introduced in the civil code. However, there have been several mistakes made in the regulation, especially the pledge agreement had still to be concluded by the creditors themselves, and they could only appoint a trustee in the framework of that pledge agreement. And also their liability could not be limited in the agreement. So, and this is also a point which is now reformed. The security trustee can already be appointed prior to concluding the pledge agreement, and with the consent of the pledger, the liability of the pledgees for action of the trustee can be limited. And finally, we have the transfer of loan and credit agreements. So this is not an assignment of a claim arising or accruing from the loan agreement, but the transfer of the agreement as a whole. And this was possible already under the civil codes which existed until now, but it had the consequence that the collaterals ceased to exist at the moment of the transfer of the loan agreement. And they could only be recreated with the consent of the pledger, which led, of course, to problems also as regards the rank of the security. Major problems in the practice, of course, especially for banks, and therefore now also in the framework of the reform, the collaterals will in the future continue to exist in case they are collateral securing a claim which is transferred to a new contractual party. So this is the case of change of a creditor, change in the loan agreement. There will be no further problem with any collaterals ceasing to exist. So that's it, and pass over to Ralph from the Netherlands.
Good afternoon, everybody. My name is Ralph van der Pas. Thank you, Torsten. I'm a TW partner in Eindhoven, the Netherlands. And I've chosen for a somewhat different approach. For an overview of Dutch security rights, I kindly refer you to the TW booklet. I will tell something about the proposed legislative changes with regard to the pre-pack in the Netherlands. Dutch insolvency law right now is under heavy reform, and one of the most important proposed legislative changes is the secret or silent appointment of an administrator before bankruptcy, which has similarities to the UK pre-pack. In these very few minutes, I will try and give an overview of the proposed changes. A pre-pack offers the possibility to prepare the sale of a distressed company prior to insolvency. Not seldom, the director of a company is confronted with a trustee who disapproves of the sale of assets which took place prior to insolvency. Quite often, the trustee uses the actio Pauliana to annul a voluntary legal act undertaken by a debtor, which has resulted in its creditors being prejudiced. The proposed introduction of the Dutch pre-pack should provide the director more certainty about the legal soundness of the deal. The legislative reforms involve the trustee already before bankruptcy, and he or she therefore can assess the intended asset deal proposed by the directors of the company from the sideline. Prior to bankruptcy, the trustee is called a silent administrator. He is regarded as a so-called fly on the wall. All parties are well aware of the fact that the silent administrator at one point will become the trustee in case of bankruptcy. Knowing the identity of the trustee to come can be quite helpful for the director, since the trustee, of course, will not annul the transaction he approved of in his capacity of silent administrator. In general, the smooth transfer of the company to a third party can also be in the best interest of the creditors and the employees, since a well-prepared transfer normally realizes higher proceeds compared to uncontrolled bankruptcies. The same goes for the possibility to save jobs, since the business can be sold as a whole instead of the sale of merely assets. Quite remarkable is that some district courts in the Netherlands already anticipated on this new legislation. Some of the Dutch district courts already facilitate informal pre-packs. As not all Dutch courts approve the appointment of a silent administrator prior to bankruptcy, forum shopping has started. Recent cases have made the Dutch public more skeptical about the pre-pack, especially in a case where the company was sold via informal pre-pack to a related party, for instance in the Estro case, or in a case where the company was given a new start but implemented significant salary cuts, for instance in the case Heiploeg. In the case Heiploeg, there was a company which was fined 27 million for its involvement in a European shrimp cartel. It went bankrupt but relaunched almost immediately as Heiploeg International after a takeover by a third party. In a solvent situation, an employee can argue that his employment contract by way of law transfers to the buyer of the company in case a transfer of undertaking takes place prior to bankruptcy. Although in this case the takeover took place after bankruptcy, the unions claimed and argued that the employees were now employed by the buyer since the general transfer of undertaking was prepared prior to insolvency. The production did not stop and the organizational structure of the company was still the same, according to the unions. However, the Dutch District Court ruled that the relaunch of Heiploeg was conducted in a proper manner. The District Court was not convinced of the argument of the trade unions that certain employees were unfairly treated. According to the judge, the rules that apply to an ordinary transfer of undertaking do not apply in pre-pack situations. The employees have no right to retain their job or working conditions. The unions have instituted appeal proceedings with the Court of Appeal. This procedure is right now still pending. Then there is the case Estro. Daycare provider Estro went into the pre-pack procedure in 2014. Immediately afterwards, a large part of its business was taken over by another daycare provider called Small Steps. Small Steps did not offer employment to all of Estro's employees, taking the position that the takeover did not constitute the transfer of an undertaking. In this case, the District Court referred 4 questions to the European Court of Justice for a preliminary ruling. The main question is whether or not the Dutch informal prepack is provided with adequate safeguards for stakeholders of the company. In other words, are the rights of employees and creditors protected in a sufficient way in case of a prepack? Furthermore, the court would like to know if the rules of transfer of undertaking are applicable in case of prepack. From my own perspective and experience, the aforementioned safeguards are sufficiently secured because of the fact that during the prepack there is also a silent supervisory judge. The silent administrator renders account for his actions to the silent supervisory judge. In my opinion, insolvency law and the prepack procedure is compatible with European legislation on transfer of undertakings, since the actual transfer of the undertaking takes place after bankruptcy. I kindly thank you for your attention. I would like to pass on to Sylvester in Poland right now.
Hello everyone. This is Sylvester Żydowiec speaking from Warsaw office of Taylor Wessing. I'm a partner here in Warsaw at Taylor Wessing. I would like to speak to you today a little bit briefly about 2 issues regarding Polish collaterals. That is the banking enforcement title, which has been, which is in the process of being repealed actually, and the alternative legal concept, which is going to replace the banking enforcement title, which is called voluntary submission to enforcement. I would just briefly would like to outline about what the banking enforcement title in Polish legislation was and why it has been repealed, and what are the alternative legal concepts which are available for the banks to secure the claims. Now, just to start off, I would like to start off by saying that, as you are probably aware, the banking enforcement title is basically an enforcement treated as a simplified procedure for pursuance of claims of the banks in Poland, with the avoidance of the face of the court proceedings. The Polish banking enforcement title has had a very long-standing tradition and was probably very similar to simplified procedures for pursuance of the claims of the banks in Denmark, Sweden, Romania, Bulgaria, and the Netherlands. And basically, the banking enforcement title was already put by the banks in the credit or facility agreements in the form of the debtor's statement, which gave its consent for the bank to conduct enforcement proceedings directly on the basis of the banking enforcement title. The fact that the banking enforcement title was so exceptional was that the bank had only the obligation to attach the enforcement clause to the banking enforcement title, meaning that the bank was freed from the obligation to undergo the court proceedings and prove its claims. So basically, having the banking enforcement title for the bank meant that the bank was entitled to go directly to the bailiff and was entitled basically to enforce its claims against the debtor. So basically, the bank was freed from the obligation to go to the court just like the ordinary debtor. Now, what was the reason that the banking enforcement title was repealed? It was actually due to the verdict of the Constitutional Tribunal in 2015, which said that the Polish banking enforcement title was not in line with the Polish Constitution. And the Polish banking enforcement title is going to be repealed actually from the Polish legal system as of August 1st, 2016 this year. And the reason for repeal was, there were a couple of reasons for the fact that the banking enforcement title in Poland was repealed. One of which was that it was claimed that the banking enforcement title was depriving the debtor the possibility to defend its rights in the court, because the title was issued by the Polish bank, was affixed, was attached with the enforcement clause, and the debtor basically had no knowledge of this happening. The second reason was that the banking enforcement title constituted the privilege especially for the banks and introduced inequality in the court proceedings, causing the bank to be in a dominant position. The other reason for repeal of the banking enforcement title was that it was only limited to banks. So basically, no other entity had this privilege, and also the banking enforcement title did not require any kind of notarization. So basically, it was put in the facility agreement with the signature of the debtor, and it constituted the document with which the bank could go to the court to attach the enforcement clause and directly go to the bailiff. what are the alternatives? What will the alternative legal concept will be for the banks to secure the claims once the banking enforcement title is gone? It is underlined in the Polish literature, in the Polish legal literature, is that the replacement will be by the voluntary submission to enforcement. The voluntary submission to enforcement works in a very similar manner to the banking enforcement title, because it only requires basically the creditor to attach, just like in the case of banking enforcement title, to attach the enforcement clause, and the creditor basically is freed from the obligation to undergo the court proceedings. But the big difference between the banking enforcement title and the voluntary submission to enforcement is that the voluntary submission to enforcement has to be done in front of the notary public, which means that it has to be drawn up in the form of a notarial deed, and of course the notarial fees will be applicable for doing so. So regardless of the fact that the general idea and the legal concept is very similar to the banking enforcement title, it will mean for the clients. It will mean for the clients of the banks the greater costs and the harder possibility to obtain the credit. Thank you very much. Now we'll pass on to my colleagues in Bratislava.
Hi, this is Radovan Pala speaking from Bratislava. And I'm a managing partner here in Bratislava in Slovakia, and I will give you a very short overview about the Slovak system of charges. This is a system which was established in 2003, and it is one of the most modern elements of the Slovak civil law. And even now, it is still one of the, I would say, one of the best elements of the Slovak civil law. It is a true backbone of the financing industry in Slovakia, because it introduced the system of charges that is easy to manage and establish, that is relatively simple to enforce, and it's not too costly. The system is based on a couple or several online public registers. When compared, for example, to Czech Republic, all these registers where the charges are registered are public, and most of them are online, accessible online. And these registers have allowed to establish charges without the handover, without the delivery of the charged assets, and thus the creation of non-possessory pledges. It is very important to have in mind that in a developing economy after the communist regime, in a developing economy such as Slovak economy, it is really important to have non-possessory pledges, because the access to capital is much more limited than in really developed countries. So this is the backbone of the system. The charged assets, basically which register is used depends on the charged assets. The movables and receivables are registered in a notary register of pledges, where even a very large amount of secured claim, for example, over several million of euros, costs only a couple hundred of euros to register. The trademarks and patents are the pledges or charges over trademarks and patents is registered in the register kept by Intellectual Property Office. The participations interests pledges are registered in the company's registers. The shares, the charges over shares are registered in the central depository, and the charges over real estate are registered in the land register. It is also important to note that it is possible to establish charges also over future property, for example, over future claims or inventory, which basically which makes it basically very similar. The system is very similar to a floating charge system. It is also possible to have fluctuating claims secured. It is only necessary to have a maximum amount stated in the register. As regards the repeated charges, there is the simple rule of priority in time, which of course then reflects on the enforcement. The rules for enforcement are also rather simple. It is important to know that in Slovakia there is no preferential treatment for any other receivables, for example, tax authority receivables or other receivables of the state. So basically the position of secured creditors is relatively very strong, and it is relatively very strong even in scenarios like insolvency or restructuring. Without the consent of secured creditors, most restructurings are not possible, and the position of secured creditors in bankruptcies doesn't differ from individual enforcement, because also in this case the enforcement is similar. In most cases it takes the form of an auction, even though a direct sale is also possible under certain circumstances. So this is a very brief overview of the Slovak system, which is, as I said, very pro-creditor oriented, secured creditor oriented, and any other form of security than a charge is much weaker. Thank you very much for your attention.
Thank you very much, Radovan, and thank you very much to everyone for their contributions. Just dealing with questions, we've got a limited time, so we won't have time to deal with all the questions I've got. But to give the chance to everyone to have a brief say to a question, could I ask a question to all of the contributors to this webinar, just to very briefly say why creditors should take and enforce security in their jurisdictions. If I could start with Susanna in Austria, if she could pass on in the usual way.
Well, we have a reliable court system, and in international standards, there are quite short proceedings and effective insolvency procedures. Forced auctions of real estate, they deliver sometimes, or quite often I would say, good results, and an insolvency administrator can sell real estate out of court. What does, however, not mean that the forced auction brings automatically a lower result. I sometimes, as administrator, also choose a forced auction, despite the fact that I get less remuneration in such a case. Be careful with security assignments of receivables, and do not accept a pledge of stocks or warehouses. And in any case, ask an expert, especially one who has experience in insolvency proceedings. And so I pass on to Thomas in Prague.
Thank you, Susanna. I would say with the new Czech civil code, the legal provisions regarding pledges were modernized and some institutes were introduced. To name a few, the negative pledge can now be registered and therefore effective towards third parties. Negotiating about the forfeiture even before the maturity of the debt is allowed, as well as the selling of the pledged thing in a private sale, which I regard as a really advantage for creditors in the Czech jurisdiction. The registering of the pledge in the pledge register provides the creditors also with a certain assurance and, most importantly, priority over any unregistered pledges. This is also a proactive approach in favor of the creditors, I would say. So, thank you. I would like on to pass to Alfred in Paris.
Personally, I would simply raise two reasons why you should come to France and to register your security interests. The first one is that we have a large variety of security interests which may be appropriate to all your needs you have, if it is a receivable which should be pledged, or a receivable for which you need something different, and particularly because we allow also the private enforcement clauses in the constitution of your security interest, meaning that you have not go to the burdensome execution foreclosure with a court, but you can set with the other contractual party the default, the events of default under which you become an owner automatically. But please be aware that each time you apply this clause, you have certainly also to have an evaluation of the asset you're getting at the point in time. And in so far, it's an advantage and a disadvantage because you have to manage the valuation of the asset. Second reason, I think it's reasonable to be in France, is simply that we have a quite sophisticated system of pre-insolvency proceedings, which allow also creditors to have a say how to reorganize a company, how to dispose of their assets or their security interests. And over the last 3 years, we have introduced effectively more rights to creditors in insolvency proceedings, which now seems to be quite a good match to all the other jurisdictions you may operate in. And you have effectively a say on what's happening. I think that are the reasons I would forward for France, and would like now to pass on to Daniel.
Well, what makes it definitely simple to take security in Germany is the fact that, except for real estate, no registration is required. To establish valid security, it is generally sufficient to have an agreement between the creditor and the debtor. All in all, I think it is definitely fair to say that Germany has a well-established procedures to secure the interests of creditors, and when it comes to insolvency, generally the insolvency administrator is given responsibility to achieve the best satisfaction of secured creditors. If the insolvency administrator is violating his duty, for example, if he is allocating sold goods to the wrong secured creditor, he might be liable for damages. So the creditors in Germany can usually rely on their securities. I pass on to Thorsten.
Thank you. Yes. So for Hungary, I would like to mention we have a big variety of securities in Hungary. For example, also floating charge is possible. There is the privileged position for pledgees in insolvency proceedings, where he's always first in the satisfaction of his claims. And before, if there is no insolvency proceeding, then also a private sale of the pledge is possible under Hungarian law, not in the relationship to consumers, but it is normally in the relationship between banks and their corporate clients. It's possible, and we can combine that also now under the new jurisdiction with call options again, so have much more flexibility for the creditors. I pass on to Ralph.
Thank you. Although the question does not really fit my presentation, I'm quite willing to promote our legal system. Or actually, it promotes itself, because the most important reason why creditors should take and enforce security in the Netherlands is because of the flexible and predictable legal system that allows banks to obtain security rights in various forms. Although we do not have a floating charge, securities can be obtained on almost every form of asset except for goodwill. And also the High Court has been quite favorable in practice to banks or creditors over the past years in cases of with regard to pledges. For example, just last week, the Dutch High Court decided that banks or creditors can establish pledges on even conditionally property rights on goods that are being delivered under the condition of a retention of title. This is just one example, but creditors in general have quite good protection in the Netherlands. And now I will pass on to Sylvester.
Oh, thank you. In terms of Polish legal system, the legal concept I was telling you about, the voluntary submission to enforcement, is one of the most popular collateral under Polish law, used in a wide variety of transactions, because it basically allows the creditors to any transactions to skip the court proceedings, to skip the obligation to undergo the lengthy court proceedings, and directly go to the bailiff to enforce their claim. Of course, once the court has attached the enforcement clause, which is only 3 days. So this is the fastest way and the most the best collateral that the creditors are using. And in case of mortgages or registered pledges under Polish law, the situation of those secured creditors is also better. It's better than those unsecured creditors, because in case of bankruptcy under Polish law, those secured creditors will be satisfied from the object of the mortgage or the object from the registered pledge, and not from the bankrupt estate. So this makes the security a little bit stronger than as opposed to those creditors that do not have, for example, the mortgage or the registered pledge or the fiscal pledge on the object. I will now pass on to Bratislava.
Yes, in Bratislava in Slovakia, the situation is very much the same. Basically, the general level of enforcement of receivables is low, and it takes a long time. So having a registered pledge, a registered charge, is the way how to secure your position. And of course, in case of insolvency, the satisfaction rate of secured creditors is generally very much higher than that of unsecured creditors. On the other hand, the establishment of a registered pledge is a very easy procedure, and it is not costly. So basically, if you choose whether to go along as an unsecured creditor or as a secured creditor, the choice is very simple. Thank you.
Thank you very much, Radovan, and thank you very much to everyone for your helpful answers to that question. That's the end of our webinar. Thank you very much for your time. As I said at the beginning, please complete the survey that you can find on the widget at the bottom of your screens. And as I also said at the beginning, we will send the recording and the slides to all of the invitees to this webinar. But I hope that was useful, a quick trip around Europe for you in just an hour, and I hope it's good use of your time, and have a very good afternoon. Thank you very much.